party, Ryan. Counsel announce appearances for the record, please.
Thank you, Your Honor. May it please the court, Riley Broyles appears on behalf of petitioner Ryan Wyndham, who appears via Zoom.
Brian Kuhn on behalf of Brittany Runyon, who appears in my office via Zoom.
This matter comes before the court at this time, I think, for the first time. There was an agreed upon order for mediation approved by this court earlier. Subsequent to that, there's been an emergency motion filed for change of custody and modification of parenting time. Counsel, I want to ask first, is there any other case from any other court that has an impact on custody or visitation rights here?
No, Your Honor, not to my knowledge.
All right.
His other daughter.
Second of all, I think counsel verified that there is no existing order in this case.
That's correct, Your Honor. I did file a motion to set temporary orders along with my petition, but that has not been heard yet either.
All right. So what has the de facto custody arrangement been, Ms. Broyles?
Your Honor, thank you, Your Honor. The de facto, according to my client, up until New Year's Eve was week on, week off, with the exchanges occurring on Fridays. And then after this emergency motion was filed is when Ms. Runyon began withholding parenting time. And my client did see the child for about 4 hours this past Saturday, but otherwise has not had parenting time since New Year's Eve.
All right, Mr. Kuhn, are you and your client still pursuing this emergency motion at this time?
Yes, we are, Your Honor.
What is the emergency?
The petitioner has provided alcohol and marijuana to his underage girlfriend. I guess for marijuana, there is no age, of course. This has been disconcerting to the respondent. In addition, they've had some violent incidents as well, with him pushing things into her and screaming and yelling. Some behavior that is into the range of unreasonable behavior. Because of the drugs and the alcohol that have been provided to his girlfriend, we are seeking an emergency order giving custody to the respondent until such time drug and alcohol and anger management can be undergone.
All right. The information regarding marijuana use in his home comes from where?
It comes from the girl that he was seeing.
It was third-party information from the girl that he was seeing, Miss Liliana Kluth.
In other words, hearsay.
And then
Yes, Your Honor.
the oldest.
Right. Right. Are there any other grounds that you're relying upon to seek emergency relief pursuant to your motion?
So his oldest daughter has said that he left them alone together, and then she also drink alcohol.
The other daughters as well have been watching him drink unreasonably. The older daughters as well.
And this is
that's all.
His daughter from another relationship?
Yes, Your Honor.
Okay. And apparently, based on information you sent to the court, the Central County District Court has taken action in that case?
It's my understanding, yes.
All right. Ms. Broyles, what would your response be?
Yes, Your Honor, thank you. We did file a formal response with the court in response to this emergency motion, but just to kind of paraphrase, on the issue or the allegation that my client provided Ms. Kluth with alcohol and marijuana, my client categorically denies that. But as the court noted, that is entirely hearsay. They did not provide any sort of affidavit of Ms. Kluth. They have not produced her for testimony today, to my knowledge. So any allegations, which frankly the majority of their allegations in this emergency motion are hearsay allegations from Ms. Kluth, who is clearly a very disgruntled, troubled young woman. And the fact that she's not here to testify, that I can't cross-examine her, obviously causes huge issues. But however, Your Honor, I think it's important to note, frankly, even if he did provide this, which he, again, categorically denies, that has nothing to do with the party's minor child. Lyric, who is 4 years old. They're not alleging any allegations of harm coming to this child. And the his other child from a previous relationship is a 9-year-old. So I would frankly take, again, hearsay, but a lot of grains of salt with a statement from a 9-year-old, who again, we don't know how this all came up. So any allegations from the 9-year-old who's providing information to, I'm assuming, to her mom, who's in cahoots with Miss Runyon, and I think Liliana seems to be in cahoots, or all these ex-girlfriends are in cahoots with each other to, gang up against my client. I mean, procedurally, there's an evidentiary wise, there's no basis to grant any sort of emergency relief here. There are no allegations of imminent harm to this child, this 4-year-old child. In their motion or from counsel's statements, they have not alleged any harm to this child. So we're asking the court to adopt the de facto arrangement, and the court is allowed to do that pursuant to KSA 23-2224 that allows the court to make orders to confirm the existing de facto custody of the child. And so that's what we're asking the court to do today, because their motion does not rise to the level of an emergency to warrant a modification of the de facto parenting time.
All right, guys. Today we are stepping into a tense custody hearing where everything begins on a procedural but highly charged note, setting the tone for a deeper family conflict. The court opens with attorneys confirming appearances, while the judge establishes this is the first formal hearing in the matter. A prior mediation order is acknowledged, but it has clearly not prevented escalation. An emergency motion for custody and parenting modification is now on the table. The judge quickly confirms there are no other custody cases or existing orders, locking in jurisdiction and pushing the case straight into serious territory as the dispute officially begins to unfold in court.
And I would also point out to the court that in their motion, they're requesting the modification of dad's parenting time, be every other weekend, 6 p.m. on Friday to 7 p.m. on Sunday. And frankly, Your Honor, if you're so worried for your child's safety, you give him a full every other weekend. I think, frankly, this motion is a way to try to get primary residential custody of this child and probably some child support. Because if you're so afraid for your child's life, you're asking for every other weekend for dad, on a weekend, if you're worried about drugs and alcohol, assuming that would be the time when that would most likely occur. So it's extremely disingenuous to file this emergency motion on the eve of this hearing date that we have. And I think the court has previously taken evidence between these parties on a PFS a few weeks ago, and Ms. Runyon has filed 2 PFAs that were summarily denied. So frankly, from my position, we're dealing with the girl who cried wolf here. She filed 3 PFAs, those didn't work, so let's try this emergency motion and see if that works. But there's just not enough here to warrant a modification of the de facto. This is just, frankly, a ploy to get primary, in my opinion. So we're asking the court to confirm the de facto today.
Mr. Kuhn, any reply argument that you desire to make?
The respondent did file a police report after the petitioner shoved a shopping cart into her stomach at the petitioner's home while the respondent was picking up the minor child. There's a Wichita Police Department case number that is firsthand, and that did occur directly to my client.
Well,
And while the minor
Mr.
child
Wyndham has a shopping cart at his home?
it was a toy shopping cart.
a toy shopping cart.
Oh. One made out of plastic?
Yes, my understanding.
And then he rolled over on her, intoxicated, 26th, and the 27th they got the call.
And on the 26th, he had rolled over on the minor child, intoxicated, and on the 27th was when she received the call from Liliana.
Asking him to pick clear cut because they were all afraid of him hiding.
Okay. All right. Anything else you want to say about that, Ms. Broyles?
I guess regarding the allegation of the rolling over, that's not in their motion, which they say occurred on the 27th, I think is what I heard. And this was filed on the 31st. So presumably if that happened and it was reported to Ms. Runyon, it would have been included in their motion, and it wasn't. But again, unless Ms. Runyon was in bed with Mr. Wyndham when this happened, I'm assuming she got this information from Ms. Klug, which again would be hearsay allegations. And Ms. Fluth is not here to testify. I'm not able to cross-examine her. They had every opportunity to produce her for testimony, and they have not done so. So any allegations that Ms. Fluth would like to bring, or any that she witnessed personally, should be disregarded by this court.
Ms. Boyles, what is the current status of the mediation that was ordered by the court?
Yes, Your Honor, that was originally scheduled for last Friday, but the mediator had a funeral, and so she had to reschedule it, and they are currently scheduled for mediation this Thursday.
Oh, all right. Who is the mediator?
Sarah Spar.
Okay.
And Your Honor, the police report was included as number 8 on my motion. If Ms. Royos wants to check number 8.
Now things shift sharply as the emergency motion moves into full force and serious allegations begin to surface in the courtroom. Claims are made about alcohol and marijuana exposure and concerning behavior involving aggression and instability at home. The requesting party argues this creates an urgent need for immediate custody intervention. But the defense immediately counters, dismissing the claims as hearsay and attacking the reliability of the sources. They stress that no sworn affidavits or direct witnesses are presented, turning the argument into a credibility war rather than proven fact. The courtroom atmosphere tightens as both sides dig into whether anything presented can truly justify emergency action.
Well, yeah, I guess I guess I can clarify my point. The rolling over incident where he was intoxicated and rolled over on the child, if that's what they're saying, was not included in the motion. Number 8, I was aware that it says that about the shopping cart incident, but again, that has nothing to do with this minor child. So I don't think that gives any additional basis to restrict his parenting time from the de facto.
Are these exhibits individually marked and numbered? I'm trying to scroll on a screen here, counsel, so.
I apologize. They don't appear to be. I apologize.
And somewhere in here, there's a Wichita police report.
Yes, towards the end, I believe.
Sure, and I did receive counsel's exhibits that he submitted last night around 4, I think it was around 4:50, and I did have a chance to review those. There were amended exhibits that were submitted around 2:30 that I briefly was able to glance at, but I've been in a meeting with my client since 2, so I didn't have a chance to fully review those. And frankly, they're hard to read. They're grayed out, and all of these police reports, Your Honor, they're highly redacted. I mean, obviously we have foundational issues. Where did these come from? And again, additional hearsay issues. But the way these are redacted is very suspect. There's huge portions of it that are redacted from the ones that I was able to review that I don't know, did they redact the things they didn't like about them that weren't helpful for their case? So I would ask the court to disregard any of the police reports for lacking evidence or lacking foundation and for hearsay.
And these I got from the police station.
I trust, since this was filed as a paternity action, that there's no dispute that Ryan Wyndham is the natural father of LAW, a minor child.
There's no dispute.
No dispute, Your Honor.
All right. We'll first make that finding that he is the father and has the rights and responsibilities connected with being a father to this child. The court has read and considered the emergency motion for change of custody and modification of parenting time. The court has also considered the response that was filed in this case. The court has also had an opportunity to at least scan or look through the documents that were just provided to the court earlier this afternoon. The court shares the concerns about the redaction and, in fact, the pertinence of some of this police information to this case. This court does not feel bound by any determination a separate court has made regarding a child belonging to one of these parties. The court simply does not see that there are emergency circumstances here that would warrant some dramatic change in parenting rights in this case. At most, in the view of the court, what's alleged is some questionable decision-making and perhaps even a suggested lack of morality. Nevertheless, there's no verification of some of these incidents, which are deemed to be serious, and the court's not inclined to interfere with the constitutional right of Ryan Wyndham to parent his child. With that said, the court's going to enter an order at this point that neither party is to drink alcohol during their parenting periods with the child. Furthermore, under no circumstances does this court authorize either party to use marijuana. That's an illegal drug in Kansas, well accepted in other states, but not in this state, and certainly not by this court. So that will be a specific order that the court will make. Since the parties have apparently had a de facto custody arrangement, the court will adopt it. The court will temporarily order joint legal custody with a week-to-week shared custody plan, exchanging what time on Friday, Ms. Broyles?
My mom usually picks her up.
Is there a consistent time and place?
It was usually around 3 p.m.
Around 3 o'clock, my client says.
Okay, I want to hear from the mother on this.
He drops her off at my house at 7:30 every morning on Friday when it's his day. His mom has never watched her on Friday, but she does watch her on Tuesdays for me. And his parents were supervising his contact with her because even they were concerned about his mental state. I just want to say that but I have no problem with him having her, but it's 7:30 in the morning on Fridays when he drops her off.
From here, the case escalates into a high-pressure clash of narratives where every claim is questioned and nothing is accepted at face value. The defense argues the allegations are coordinated and unreliable, pointing to past dismissed protective orders as evidence of a pattern. The discussion intensifies as police reports are introduced, including an alleged physical incident involving a shopping cart, which immediately becomes a point of dispute. The judge carefully probes what is factual versus what is redacted or assumed. As the hearing progresses, hearsay objections and evidentiary concerns dominate, shifting the focus from emotional claims to strict legal scrutiny over what can actually be trusted.
Your Honor, 7:30 in the morning on Friday is fine.
All right. Ms. Broyles, I'm going to ask you to draft an initial order in this case. Since you represent the filing party, we need to have a finding of paternity and for this court to make initial orders in the case. The court will reiterate its order for mediation in this case. There are some issues here that these parties need to work through and need to discuss, and I think that the mediation with Ms. Farr would be very helpful, and perhaps parties being able to express their concerns and to try to reach appropriate agreements regarding the best interest of their minor child. I also want to specifically note here that even though there are some areas of concern here, it does not appear that at any time this 4-year-old child, who's the subject of this case, was ever in imminent danger. This rollover incident, let's just say, Mr. Wyndham, these things happen. You need to make sure, though, that at all times you conduct yourself in a way to keep your child safe and be ever mindful that you're a lot bigger than her. And even rolling on her could cause injury. So be careful. That's just what I'm asking you to do. All right. Regarding initial orders in the case, Ms. Broyles, from your perspective, is there anything else that needs to be addressed at this time?
Your Honor, the only other issue would be the issue of child support. We did file a DRA and a proposed child support worksheet. I don't see that Ms. Runyon has filed a DRA, and we haven't exchanged income information. So I think between counsel and I, we probably can do a agreed child support worksheet. We would just need to exchange income information and confer regarding child support.
What is your proposed effective date for the child support order?
Your Honor, we filed our motion on October 24th. So November 1, I think would be appropriate.
Mr. Kuhn, would you like to be heard on the effective date of child support in this case?
That seems reasonable, Your Honor.
Very well. November 1 will be the effective date.
Maybe.
Council, I would just ask you to immediately exchange any pertinent information necessary to do the child support worksheet so that there's no further delay. This case has been pending since October. So the sooner we get an appropriate child support order in effect, it'll be based on a shared residential custody schedule. But the better I think things are if we get that order operative and going.
Your Honor, if
Yes, Mr. Kuhn.
if the exchange of the child could occur at the police station, that would be greatly appreciated.
Why is that necessary?
My client is in fear of her safety.
There's been
Your
some,
Honor, I would object to that. I mean, the parties have been exchanging fine up until the cessation of his parenting time by Miss Runyon. And I think a lot of times, my client's parents help facilitate the exchanges. But she's filed 2 PFAs and they've both been found, they were both dismissed. To say she's in fear of her life, I don't think there's enough found by this court and by Judge Hart that she didn't have enough for a PFA. So I don't think she has enough for, and I think that would be traumatic for the child to exchange at the police station. And I don't see what benefit that would have.
Okay. Mr. Wyndham would otherwise be dropping off and apparently picking up at the mother's house. Is that right?
we've been meeting sometimes at Dylan's. Sometimes he'll drop her off at my house. I'm okay if he comes to my house to do it because I have cameras, but I'm not comfortable going to his. Last time my daughter was there when he shoved me, there's even a police report from his girlfriend.
Your Honor.
Okay. All right. With that said, all right. Apparently the mother is agreeable that the drop off can take place at her residence, which makes all kinds of sense. Where does the father live?
Yeah, I guess so.
Augusta. He's fine with exchanges occurring at mother's house. That's fine.
All right. So he'll do his pickups there as well. All right.
I feel comfortable with that.
Mr. Wyndham, you can have another responsible adult person in the car with you when you do your pickup, but they're to not interfere in any way with your business with the mother of the child, okay?
Yes, Your Honor.
I don't know.
Okay. All right. Preferably a family member of some kind if they're available. If not, you're certainly authorized to do it on your own. Okay. So the next exchange will be Friday morning? Is that what's contemplated here?
That would be fine, Your Honor.
All right.
Well, since his parents have her right now, will he just go pick her up from them since it's supposed to be his week with us?
Currently, my understanding is the child is with the petitioner, and so
No,
Start
his
fresh
parents.
on
or
Friday.
his parents, excuse me.
Your
So
Honor,
he'll be picking up from the parents.
Your Honor, my client's position, I mean, it's Tuesday evening. He would like his full week. I think it makes the most sense to, mom can have this week. We start fresh on Friday with him picking up from mom's house at 7:30 and then we alternate from there. So,
Court's inclined to agree. Remember at all times, parents, that this is all intended to be in the best interest of your minor child. So I would ask you to participate in mediation in good faith. Try to work with each other. You know your child better than anyone else in the world to try to work out the best possible plan for her long-term welfare. Good luck in that regard. Again, Ms. Broyles, if you'll draft an appropriate journal entry of paternity and documenting the temporary orders which have been implemented by the court here today.
yes, Your Honor, I will do that.
Do you need any further clarification regarding those orders?
I do not believe so. Thank you.
Mr. Kuhn, do you?
No, Your Honor.
All right. Then if there's nothing further at this time, the Wyndham and Runyon matter will currently be in recess.
In the final stretch, the judge steps in decisively to separate allegations from legally supported facts and bring structure to the conflict. Paternity is confirmed, and after reviewing all submissions, the court finds no emergency that justifies altering custody arrangements. Instead, the judge imposes targeted behavioral conditions, including strict prohibitions on alcohol and marijuana during parenting time. A stable week-to-week shared custody plan is maintained rather than disrupted. The court also moves forward with child support arrangements, exchange logistics, and mediation scheduling to reduce tension going forward. The session closes firmly on the principle that despite conflict and accusations, the child's best interest remains the controlling standard.